Welcome, everybody, to our introductory lesson on the subject of equity and trusts. What we're going to do in this lesson is introduce the concept of equity, introduce the concept of the trust, try to come up with some kind of definition of both of these before outlining the scope of this series of lessons, the detail of which we're going to be talking mainly about the law of trusts specifically, but of course equity is important in providing a useful amount of background to this area. So this lesson is going to take an introductory look at the concepts of equity, as well as outlining the scope for future lessons on this subject. Now, we consider that equity and trust is often one of the more advanced areas of law which is studied at university. It's very, very rare. I've not actually seen an example of a university that offers a law degree teaching equity and trust in their first year of study. For the most part, this is an area of study that is done in second or third year, most often third year. And so ultimately, when we talk about equity and trust, we do have to think of it as something of a more advanced area. But just like with any other area of law that we have previously studied, or that you may have previously studied, the subject of equity and trust is one which has some areas of complexity as well as areas of relative simplicity. Now, ultimately, if you are somebody who is studying law at university, you may enjoy the law of trusts and equity and trusts. You may hate it, but that is the case for basically any subject that you study and any module that you pick. We'll introduce the concept of equity in this definition, in this lesson, should I say, and then give a definition of a trust as well. Despite the fact that a formal definition that is accepted by all is relatively elusive in terms of this area of the law. So let's begin with equity. Let's begin with what equity actually means. Well, if we're going to talk more about the etymology of the phrase equity, it derives from the Latin equitare, shall I say, from the Roman law tradition, equitas meaning some kind of justice, maybe fairness, maybe equality, these kinds of phrases. Now, this is how the concept of equity is commonly understood to this day. People talk about equity in this idea, in the sense of this kind of fair outcome, the idea of fairness in achieving some kind of goal. Now, within our jurisdiction, within the jurisdiction of England and Wales, the idea of equity is an idea that is born out of a particular body of law which developed and was developed by something known as the English Court of Chancery. Now, from an historical perspective, equity was something which developed alongside the common law. So we had almost two dual jurisdiction for cases to be brought. You could maybe bring a case within an ordinary common law, English common law jurisdiction, but you could also bring a case through the English Court of Chancery. And the reason why this was distinct, and the reason why the English Court of Chancery was created in the first place, was that this extra jurisdiction was seen to be able to provide legal remedies in circumstances where it's understood that the common law was proved to be particularly unable to deal with outcomes in a fair and just way. So maybe there might be the application of the English common law accurately, but that the English common law doesn't really allow for any kind of flexibility to essentially provide some kind of fairness for a case by case basis. So bringing the case on a case by case basis might not be as it might not bring about the most fair and equitable outcome if we were to apply the English common law in a strict manner. And so that's really where equity steps in, and the English Court of Chancery steps in to try and alleviate and remedy legal issues in ways which essentially allows us to apply equity to the facts of a particular case. Now, so essentially where the common law was inflexible, equity could step in to achieve a just settlement. And so this is really how the idea of equity began to develop and began to become interwoven and enshrined within the broader corpus of English law. According to Hudson from 2001, equity is the means by which a system of law balances out the need for certainty in rulemaking on the one hand, with the need for sufficient judicial discretion to achieve fairness in individual factual circumstances on the other. So, ultimately, equity is a very important part of the history of English law and the development of the English common law. Now, we'll talk more about the history of equity in future lessons' time. In fact, that's what we're going to begin with after we've done this introductory lesson. But for now, it's important to note that the concept of the trust, so moving a little bit away from equity, but or at least equity specifically, and thinking about the concept of the trust, well, the concept of the trust in English law is one which develops out of this mode of legal process, that we know to be called equity. Again, by Clements and Abas from 2009, they say that it is correct to describe trusts as a creation of equity. It comes out of equity, it is a creation of equity specifically. And so this begs the question, well, okay, then what is a trust? What do we mean when we talk about a trust? Now, we know what equity refers to. We know that it refers to a legal jurisdiction which is ultimately tasked with providing fair and just outcomes in the circumstances where the common law was considered to be inflexible, where it was considered to be not fair to apply the common law in the way that it maybe ought to be applied. And we also know that the idea of a trust is one which has developed out of this jurisdiction of equity, because we mentioned this on the previous slide. Well, when it comes to a definition of a trust, I personally like the Pearson-Stevens' definition from 2015, which is the following. They say that the trust is the most important creation of equity and is a form of ownership of things or property which allows someone to manage property for someone else's benefit. Okay, that's really what a trust could be described quite broadly as. In doing so, it essentially allows us to identify a number of different individuals or a number of different actors within the kind of trust relationship. So, for example, there would be the person who owns the property, who has legal ownership of the property. There is the person who is the trustee, who is essentially the person who is holding that property on trust for someone else's benefit, and that person's benefit is known as a beneficiary. We'll get to that in future lessons' time in more detail. So, speaking of which, let's think about the scope of this series of lessons. In consideration of the fact that we're going to be talking about equity and trusts, we're going to spend a good amount of time examining both. Of course, we're going to spend a lot of our time talking about the trust, given the fact that, as described in this previous definition here, the trust is the most important creation of equity. So, let's begin by talking about the concept of equity. That is what the first set of lessons is going to be all about. We'll talk about the historical development of equity, which includes the early origins with King Edward I, the development of the Court of Chancery, the Judicature Acts from 1873 to 1875, the fusion debate between the kinds of equity, Court of Chancery, and the common law, and then the modern study of equity, seeing where equity actually applies to this day. We will then move on to talk about what equity actually is, looking specifically at the various maxims of equity. In the second topic, we will talk about the concept of the trust in a very broad and overview-like way. So we will talk about a basic definition of a trust that we've already explored, but we'll go into it in a little bit more detail, talking about the various different relationships that exist within a trust. So who is a trustee, what is the settlor or testator of a trust, and who are the beneficiaries of a trust. We will then take a very quick overview of the types of trust which exist within English law. This includes the likes of the bare trust, express trust, fixed trust, discretionary trust, public trusts, etc., etc., etc. That's a non-exhaustive list that is cited there, by the way. In the third section, we will talk about the requirements that are needed for the creation of a trust. This refers to our understanding of the three certainties. These are the certainties of intention, subject matter, and objects. In the fourth topic, what we will do is talk about the constitution of a trust. This is referring specifically to the methods of constitution, including the transfer of legal title, the unconscionability rule, imperfect constitutions, and a little brief overview of this idea of proprietary estoppel, something that we will look at in land law as well. Topic 5 is going to talk about the distinction that is made between charitable and non-charitable trusts. So we'll talk first about the examination of a trust for non-charitable purposes, including the beneficiary principle, perpetuity, certainty of this non-charitable trust, trust for persons, trusts and gifts, trusts, and the use of corporations. And then we will talk about an examination of trusts for charitable purposes, including the benefits of a charitable trust, specific charitable purposes, including making trusts for political objectives, educational purposes, health and life-saving, religious purposes, environmental protection, and other types of charitable trusts which can exist. Topic 6 is going to explore the idea of the constructive trust, the general application of the constructive trust, third-party liability, and the nature and rationale for the existence of constructive trusts within English law. After that, then, we're going to then start to talk about some of the specific members of the trust relationship in more detail, talking about what the duties and the powers of a trustee may be. So these relate to the various duties imposed on a trustee, including a trustee's duty of care, the various ideas relating to fiduciary and non-fiduciary authority, as well as the abuse of a position by a trustee. Section 8 will look at the powers of trustees, including the power of investment, the power of maintenance, and the power of advancement. Then we will talk about breach of a trust and remedies for said breach in Section 9. This includes talking about what it means and how breach of trust actually occurs, as well as the liabilities that are imposed on individual trustees for breach of trust, and then finally thinking about remedies for a breach of trust. These include equitable remedies as well as things such as injunctions. Welcome back, everybody, to our study of the law of trusts. In this lesson, what we're going to do is talk about the concept of equity. This is going to be essentially the first 3 or 4 of these lessons on the subject of trusts. The first chapter of this major topic is, of course, looking at the idea of equity, looking at the historical development of equity, and then looking at some of the major maxims of equity. The aim here isn't for you to have a substantive, overarching understanding of equity in any particular great detail, but the aim is for you to understand equity to a good enough extent to then be able to transfer your understanding of equity to looking at equity's greatest invention, which is, of course, the nature of the trust. And then we'll start to talk about the trust in more detail, talk about the formation of the express trust, all the different kinds of formalities, constitution, etc., etc., etc. So, like I said, the previous lesson was an introduction to the subject of equity in trusts, talking about that subject in its general format. We noted that we're going to go through and spend a lot of our time in this series of lessons looking at the concept of the trust, because essentially this is a subject on law of trusts. This is a subject on trusts specifically, which is, of course, the most important invention out of equity. But is a way of getting some kind of foundational knowledge of equity in more detail. I'm going to spend time in this lesson, the next lesson, and the lesson after that talking about this particular concept. So we're going to ask the question more formally in this lesson, what actually is equity? Now, this is a question that we touched on briefly in the last lesson, and we examined in its general format in the last lesson. But we're going to go into a little bit more detail in this lesson, and then in the next few lessons we'll talk about how this concept began to emerge within the history of English law, talking about the development of and the rationale behind this idea of the Court of Chancery, the way in which the Court of Chancery would develop over time, the way in which the Court of Chancery in some cases would actually clash with the common law at instances, and there are notable examples during the early period of the Stuart dynasty where this happens, and then in the Victorian era we see the fusion of law and equity with the Judicature Acts, the Supreme Court of Judicature, and the establishment of this merged system where you have both law and equity being adjudicated under the same jurisdiction. So the previous lesson, we had something of a definition of equity, noting that it was a concept which related to the idea of fairness, the idea of justice potentially, and so as a result of which we can have a basic understanding of what equity actually is. But it won't be until we've looked at these lessons in their entirety that we understand what actually equity is, because I can say equity is fairness, and equity relates to things pertaining to justice, for example, and we can talk about the theoretical approaches and the procedural approaches, which we will do in this lesson. But until we have an understanding of what equity actually involves and what equity has involved us understanding over the history of English law, we're not going to have the best definition or understanding, because we can essentially divide the subject of equity into two conceptualizations. We can talk about equity in the general by talking about the theoretical approach to equity. This includes examining things like the fundamental rationale and justifications for having the influence of equity within the common law. But there's also the legalistic approach, which is essentially how this applied to specific cases and the ways in which it would apply to specific cases. So when we look at the theoretical approach, we know, of course, that from the standpoint of theory, equity is a concept which does indeed relate to things pertaining to morality, to justice, and to fairness. According to Cohen, for example, the concept of equity is one which derives mainly out of the works and the ideas of the canon law, and the word itself, equity, comes out of the Latin equitas, the Roman law tradition, which was the sort of Latin conceptualization of justice, equality, symmetry, and fairness. So we see this transferal from the Roman law, civil law tradition of equitas into something of the religious canon law traditions, and then we see this develop into this concept of equity itself. It's a little bit messy how it all begins to amalgamate together and to form into the concept that we know of today, and that's really more of a subject for a legal historian more than somebody who is studying the law of trusts. So we will not spend too much time doing that, looking for the origins of equity in either the canon law tradition or even within the Roman law tradition. When it comes to the legalistic approach to equity, the actual way in which it was applied on a case-by-case basis, we can look at the application in the procedure of legal systems. We will say that equity was essentially a body of law that would develop out of the English Court of Chancery. The reason why it became a body of law, almost its own separate jurisdiction, was because we see a shift away from the employees of the Chancellor to the application of judges within the Court of Chancery, and this sort of imbued equity with a certain amount of legalism, which essentially bogs equity in the Court of Chancery down to the same kind of critiques that equity was supposed to solve when we talk about the rigid, harsh nature of the common law. While equity exists in both the civil and the common law jurisdictions, if you remember back to that previous slide, equity derives out of the Roman law, the concept of equitas, but it also derives out of the canon law, both of which were heavily influential in European legal systems. So it makes sense to suggest that it comes out of not just the common law in England and Wales, but also it comes out of the civil law traditions over in the continent. Under the common law, however, even though it derives out of or exists within both civil and common law jurisdictions, in the common law, equity did remain a separate and distinct jurisdiction until the Judicature Acts of 1873 and 1875. Now, the aim for the Court of Chancery and the aim of having a separate jurisdiction was to essentially make attempts to overcome the perceived inefficiencies of the common law, where the common law would be applied in the correct and ordinary way, but it was seen that the strict application of the common law leads to an injustice or an unfairness, then equity is said to be able to step in. And this all derives out of the monarchical authority that the king had to step into legal disputes and to utilize his power as the divine right of kings to make things right, to make changes to the particular decision of a case, to alter in a perceived manner manner to make a situation more fair or more just, to be able to deliver justice, essentially, which is one of the main aims of the monarchy. And so out of this concept, we then go from the king essentially delegating that authority to his chancellor, and then the chancellor ultimately delegating that authority to his chancery, and establishing eventually under the reign of King Edward III a formal place where the Court of Chancery would preside. We'll get to that in the next lesson. But one very useful definition of equity, or at least a definition of how equity operates in relation to the common law, comes out of the Dudley case of 1705, where they say that now equity is no part of the law but a moral virtue, which qualifies, moderates, and reforms the rigour, hardness, and edge of the law, and is a universal truth. Equity, therefore, does not destroy the law, nor create it, but assists it. This is a very nice definition, or at least a very nice description of what equity essentially does. It talks about it being something which it almost transcends legal values. It is something of a moral value, and what it does is it sees the law itself. It sees the decisions that have been handed down through the common law, sees the way the common law is quite harsh. It is quite rigid. It has got something of a sharp edge to it, if you will. And what it does is assist the common law in being able to deliver justice in the most appropriate way. It does not destroy the law, nor does it create the law, but instead it assists the law. So the issue, what we find ultimately with the development of equity and the Court of Chancery, is that as it begins to develop, it begins to essentially take on a role of its own as a distinct body of law and legal rules. So whereas equity was seen as a very flexible, almost precise tool for the application of rules to specific cases, one of the things that we're going to talk about in the next lesson and the lesson after that is this idea that equity acts in personam, one of the major maxims of equity, the idea that it is essentially applied to the personal characteristics of a particular case. And so as a result of which, that made it very flexible and very applicable to various different circumstances. But as it begins to develop into its own distinct body of law and legal rules, partially because of the influence of judges being part of the Court of Chancery, or beginning to be part of the Court of Chancery, you could argue that the Court of Chancery began to become impeded just in the same way that the common law was impeded, with quite strict adherence to legal principles. And it wouldn't be until we see the Supreme Court of Judicature that we see something of a fusion between these two rules. Now, there is still debate about whether or not fusion has actually happened, and this is something that we're not going to get into in this series of lessons, but the quote-unquote fusion debate around whether or not law and equity have actually officially fused together, or that they still remain distinct despite having the same jurisdictional, the same area of jurisdiction, is a debate that will continue to take place.